morning, everybody. Thanks for coming to this panel on data-driven innovation, privacy and national sovereignty in a global world. My name is José Piñar. I'm a professor of administrative law at CEU San Pablo Universidad Madrid. And also, I'm the holder of the so-called Google Chair on Privacy, Society and Innovation at the university. Is the first chair created and supported by Google in a School of Law Faculty regarding privacy, society, and innovation. The Google Chair was created in 2012. And we are very proud to participate again in this conference. This is the second time that we participate with an organization of a panel here in this Congress. The Google Chair organizes every year one international conference in the last week of June, and also participate in a master's degree on privacy, access to information and information security. An official master's degree at the university is the first one recognized by the Spanish government as an official master's degree on privacy, access to information and information security. Also, we organized more or less one each 2 months, a so-called permanent seminars in which we can discuss together with experts on privacy about the most important topics about the relationship between privacy, society, and innovation. Also, we have an award, an annual award for the young research people on privacy. And the Google Chair supports also this master's degree. We are really proud to cooperate in this panel. The moderator is Victoria Nash, on my left. She's Deputy Director and Policy and Research Fellow at the Oxford Internet Institute. Oxford Internet Institute is a multidisciplinary research and teaching department at Oxford University. And her research interests concern, among other very important topics and very different topics, the application of fundamental values, fundamental liberal values in the internet era. We organize a very international panel with speakers from Australia, from Washington, from Paris, from Oxford, because we are talking about a very important issue in privacy, the extraterritorial application of law. If we are talking about local laws, we have to know, and we know, that the scenario is not local anymore. It's global, it's a planetarian scenario. So it's a very important challenge for lawyers, and not only for lawyers, but also for practitioners, on how to apply a local law in a global or international scenario. Well, thank you very much to everybody, to Michael, Edison, Ariane, and Dan, and Victoria, you have the floor to moderate this amazing panel. Thank you very much.
José Luis, thank you very much for that very generous introduction and this exciting panel that we have that's keeping you from your lunch. So we're going to make sure that we move some heated debate quite quickly. The format of this panel will be 4 brief 10 to 12 minute presentations from my wonderful colleagues down here. And then we'll make sure that there's time at the end for you to ask some questions. So without further ado, I'm going to introduce our panelists. To my left here, I have Michael Camilleri, who is a former diplomat and lawyer based in Washington, and who's currently the director of the Peter D. Bell Rule of Law Program at the Inter-American Dialogue Institute in Washington. Thank you. Next to him, I have Edison Lanza, who is a special rapporteur for freedom of expression at the Inter-American Commission on Human Rights of the Organization of American States, also based in Washington. Thank you for coming as well. I can't see past you at the moment, but I know down there we have Ariane Moll, who is a senior partner at Bird & Bird Legal Practice in Paris. Her official title, I believe, is Joint Head of the International Data Protection Group, but I know on the website it basically just says she's Queen of Data Protection, and I really hope you have that on your business cards. Last but not least, academic colleague at the very end, pleased to meet Dan Svantesson, Professor Dan Svantesson, I should say, because our titles matter very much to us, who's co-director for the Centre for Commercial Law at the Faculty of Law in Bond University in Australia, who's come all the way around the world to be here. So thank you, all four of you, for your time today. And we are going to kick off as a first speaker with Edison. Please, over to you.
Okay.
Thank you.
Good morning, everyone. Thank you for the wonderful presentation, and thank you also for the São Paulo University and the degree for this invitation. First time here, I'm very glad. First of all, I want to say that our perspective is in regards freedom of expression and the link with different legitimate objectives to protect, like personal data and privacy. And my first concern about this discussion, I would like to express the concern about this type or some type of select censorship around the world in regard with the link, the removal, some contents for different reasons. Sometimes for decision of their own platforms or their own intermediaries in internet, but other times in link with the regulation of the states and with the law or the decision of the regulator of privacy or regulators or different regulators or the judges also. And this obviously is have an impact in freedom of expression because in under the 13th article of the American Convention of the Article 19 of the ICPR, the freedom of expression have a great protection. All of the discourses of the contents that flow through internet have a very, very important protection. And those limits in regards with the internet have different approach in the different jurisdiction and different cultures. Imagine that, for example, not only in regards with protection of privacy or the right to be forgotten, but also, for example, in Russia with the law that criminalizes the gay propaganda, or, for example, in Venezuela, that recently passed a law about hate speech with a very wide definition of hate speech, or in Thailand with the discourse of critical discourses against the king, for example. If this type of law, definition, and cultures have a global impact, is really problematic for freedom of expression and for the working of internet regarding the borders. This is my first. I don't see anything here.
There is no light.
The second remark have relation with the Costeja case and the impact through the borders, and in particular, for example, in Latin America. There is a trend that in many cases in Latin America, the idea of the right to be forgotten, the right to the people to remove or to ask for the data controller, the platform, the research, the engines, the search engines, to remove some content. Now is using in Latin America for remove information in regard to public interest. It's a fact that in many cases, people that are under investigation for corruption or for violation of human rights call for the platform or for the regulator to remove this type of content. No? I know that the main preoccupation for the people that working in data protection is obviously not to attack the public the information of public interest, even the protect of the privacy of the common people. But we need to take in present this impact. It's really a way that in Latin America that right to be forgotten is using, and then have an impact. If the situation is worse, if now, for example, in the case of France and the recent decision about the application all over the world of this type of removal of content, maybe come to use by the people in Latin America here in France and other countries to allow to take a decision to remove some content around the world, and finally the impact in our countries is really important and really worse. Let me say that under the protection of freedom of expression in the American hemisphere, public officials are subject to greater scrutiny for society, and for that reason there are a strong presumption that the public information don't have a censorship, a prior censorship, and the delete information or removal information they have an impact in this way. In other words, in Latin America, the people won't forget, and this type of removal of content could be an impact, really a great impact over the right of truth and the right of memory that now is a really important standard in Latin America. For our standards, the least information or removal information only proceed when there are substantial damage to privacy and dignity. It must always be ordered by a judge or a court with all the guarantees of the due process. Other problem or other concern about that of this type of approach is that the right to be forgotten in many cases it's in the hand of the platform and the data controller that a person who knows perhaps in San Francisco maybe decide what kind of information is keep hold to the search of the people, to el alcance of the people, and which information may be deleted and disappear of the engineers. And it's obvious now in the digital area, the role, the paper that this kind of platforms play in the flow of information, in the possibility to seek information is really very important. And in many cases, like 1 million of pages in the past year, delinked by this type of private decision, private censorship, that it's a very complicated problem. Let me conclude with some question, and perhaps the follow colleagues and panelists could help me to ask them. There are problems with presented by the extraterritorial application of the decision based on this so-called right to be forgotten. In many cases adopted by the data protection regulators and even in judicial authorities are directly related to the lack of precision and vagueness of the concept itself. I feel that the definition of right to be forgotten in terms of information that is irrelevant or unnecessary or extemporaneous is a really vague definition to limited the right to seek the right to freedom of expression. And the internet does present with a new question regarding issues of jurisdiction due the transitional and the border nature of the internet. The extraterritorial application of an extreme measure, such as the list or disindexation, can have a disproportional effect on freedom of expression, especially in the light of the problem that I have previously explained in this presentation. Thank you very much.
Edison, thank you very much for that really excellent way of starting off the discussion here. I just wanted to ask one clarificatory question. You gave some very good arguments as to why you thought these particular examples of legislation were problematic when applied outside a jurisdiction, but do you object to the fundamental principle, if you like, of the idea that any sorts of laws about the internet should apply across multiple jurisdictions? Mm-hmm. So is it the effects of these particular laws, or is it the principle more generally?
Yeah. No, really my concern is the impact that these decisions that made in one jurisdiction or respectable culture, juridical culture, but the impact that we have in another context. In particular, in many cases in Latin America, is a fact that the judiciary independence is not strong in many countries, and there are some cases on it's really notorious that a former businessman or a former military try to clean in your past to go to the public life or get impunity, and then the concern of the impact of this kind of measure in taking place in one country, but with impact in globally, it's really my first concern about that.
Thank you very much. I think we'll move on to our second speaker. So Ariane, I'll go to you.
Does it work? Yeah. Hello? Yeah. Yes.
Yeah.
Okay. So hello. Yes. I would like to present some aspects of the GDPR which find their limits in the sovereignty of both of the EU member states and also in the sovereignty of the third countries outside of the European Union. I have prepared a very short PowerPoint, and José Luis, I will take your prefer to stand, so I will just borrow your microphone just for a while. Okay, so first of all, does it work? Does it work? Does it work? No, it doesn't. So I don't know why. Doesn't work. Okay. So yes. So first of all, some notions of about the GDPR versus EU national laws. So you all know about the purposes of I can't do it. I'm sorry. I shouldn't have done that because it cannot work my PowerPoint. So yes. So I just wanted to focus on two purposes of the GDPR. The first purpose, which you know very well. I'm sorry. I'm going to use you as a. The first purpose, which you know very well, is to have unified rules. It's to prevent divergences between member states. And why? It's very understandable. It's one global regulation. This is why it's not a directive. To avoid divergences between member states, and of course it is made to protect the people in the European Union and also to facilitate things for companies, for organizations within the European Union. This is one of the purposes. The other thing is, of course, the extraterritorial scope, which is a very very big focus in the GDPR, and the principle is easy to understand. If you are outside of the European Union with no presence in the European Union, but you propose goods or services to the people in the European Union, then you must abide by the GDPR. So these are the two big principles: no divergences between the member states and extraterritorial scope to protect individuals. Now, how does it work? It doesn't work. It doesn't work. But there are a lot already. Already we can see that, unlike that, there are a lot of divergences already in the local data protection laws, which were either adopted or which are being prepared in the European Union by the various member states. So each jurisdiction is doing different things about data protection. I'm giving here a few examples about the fact that there will still be notifications to be done to the data protection authorities or even request for authorization, but of course not about the same things. It's going to be different in each member state. So I gave some examples. In the UK it's going to remain. In France we will still have authorizations. In Denmark for certain things, each time different. In Hungary also, whereas in the Netherlands and Czech Republic it was suppressed. In Italy there will be no notification, but my Italian partner just told me that there was a legislation which just passed in Italy and which requires every controller to notify a copy of its privacy notice, of each privacy notice to the Garante, to the Data Protection Authority, if the privacy notice is based, if the processing is based on the legitimate interest, and of course the Garante has a right to refuse. So it's a kind of new notification which is going to happen in Italy. So you can see just with those very few examples, a lot of divergences already. And speaking of information notices, I succeeded on doing it this time. So, and speaking of information notices, just a few examples of the fact that in France we have different requirements which are going to remain even when the GDPR applies. Otherwise, I wouldn't be talking about it. So, for instance, in France only, you have one additional information element to put in the information notices, which is a specific right, which is the right for every individual to give orders on what should happen to their data after they are dead. It's a very nice thing to put on an information notice. You have a right to give orders about what happened to your data when you are dead, which is something always very nice to say. But if it's not in the information notice, then it doesn't comply, even if it complies with the GDPR, but it doesn't comply with the French Data Protection Act. Another thing is, and it was one of the bases for the sanction to Facebook Inc. and Facebook Ireland by the CNIL in April last year, is the fact that in France, you must, having a privacy policy in place is not sufficient. You must, in addition, have a specific information notice on each form and on each place where personal data are being collected. Might be a very good idea, but it makes things difficult for a multinational company. It's another example of national laws, which is completely different from what the GDPR says. Now let's come to extraterritoriality and how it works, how it can work in practice. José Luis, I need your help. Yes, okay. Okay, how is it going to work in practice with difficulties? I'm talking about, of course, I'm talking here about companies, either processor or controller, which have absolutely no presence in the European Union. Let's take, for instance, the example of an e-commerce website. Okay, you have an e-commerce website, no presence at all in the European Union, but selling things on the website to individuals within the European Union. So how is this website going to comply with GDPR requirements? What are the requirements for a company without any presence in the EU? First of all, because this is really the requirement, this company should appoint a representative in the European Union. That's one real requirement. I mean, otherwise it's a violation. So how are they going to do this? First of all, nobody is going to want to be a representative of a company which is outside of the European Union with no presence in the EU. It's also a requirement, you know that it has been a requirement of the European Data Protection Directive since 1995, and who has ever heard of a company with no presence in the EU appointing a representative in the EU? I had clients asking me to find a representative. Sometimes it can happen in Germany, some people accept to get paid for that, but not in other countries. And now that the sanctions are going to be so high, who is going to accept this? So even a company which is willing to do it is not going to find anyone to do it in the European Union. And secondly, why should they do it? Because, of course, if they do it, the purpose is to make is to allow the data protection authorities to catch them more easily because they have a representative in the European Union. So, what would be the interest for for companies outside of the European Union to do such a thing? I mean, they will not do it. If you take the example of WhatsApp, for instance, the Article 29 Working Party has been writing a lot of letters to WhatsApp to ask them to amend what they were doing and their practice and the sharing with Facebook of personal data of the users, but it had no effect. And WhatsApp is considering that European data protection law does not apply. And of course, it's much easier for a company with no representative and no presence in the EU to say this. Now there is an injunction, there was an injunction to WhatsApp in December by the CNIL. We will see what happens, but it's always much more difficult. It's not only representative in the EU. Let's imagine that this website, for instance, is selling beauty products. So it's selling beauty products. So it has to do some cosmetovigilance. Of course, it's compulsory. It's mandatory under health requirements. So of course, because it's mandatory, it's processing health data. Because it is processing health data, it should appoint a DPO which is going to collaborate with the data protection authorities of the European Union, do privacy by design, PIAs, etc. Okay, so I am a website. I have no presence in the EU. I'm going to appoint a representative in the EU, and I'm going to appoint a DPO, and this DPO will have the function to collaborate with the data protection authorities.
Ariane, I'm really sorry. One more minute.
Yeah, okay, one more minute, but that's enough. And what about the data transfers? That is also something. How can we reconcile the concept of data transfers, which are outside of the EU, which are from the EU to outside of the EU, with the fact that the controller or the processor is anyway outside of the EU and nowhere else, So of course the data go outside of the EU, but how is the controller or the processor going to abide with the principles? Are they going, for instance, to have a contract with themselves, a transfer contract with themselves? It's really something that is very, very difficult to figure out. And of course, there will be enforcement by EU DP authorities, but difficult in practice because you can always sanction. But how is the sanction going to be exercised? And there is no one-stop shop, because one-stop shop is only for companies within the EU. It's the companies which have no presence of the EU, they have no right to the one-stop shop. No right. So they have all the obligations, but they don't have any of the benefits. So it's really something that is difficult. So it's like, having enemies and putting okay. So that's the way they consider it, really. And well, to conclude, what I would like to say is that it's not good for data protection because it does not protect the individuals, because not a lot, I don't know, but many companies at least which are outside of the EU with no presence in the European Union, they are ready to understand that they should do things, that they should have policies in place, that they should respect the rights, etc. But when they understand that in order to be compliant, they have to do lots of other things that are just completely unrealistic, then often they just give up. And this is something that is, in my view, a problem for the protection of individuals, and that's not what is wanted. And just to conclude, the Article 29 Working Party has said that it will provide guidelines, opinion, no one knows, about the problem of extraterritoriality, Article 3, and especially combined with Article 7, the need to appoint a representative in the EU. And we don't know when it's going to happen, but, well, there is something to be done, in my view.
Yeah, we can hope. Ariane, that's fantastic, thank you. And I fear you're so good on this subject that I'm going to email you all my GDPR queries going forwards. I'm going to move quite swiftly on, if that's okay. So we're going to take a slightly different tack now, and we're going to talk not about GDPR, but about the right to be forgotten. So, Michael, handing it to you. Thank you.
Thanks so much. It's great to be here. José Luis, Rosario, really grateful for the invitation, and great to be here with my fellow panelists. As Victoria mentioned, I'll take a swing at the themes that are raised by this panel through the prism of one particular issue, which is the right to be forgotten online, which I think really does underscore and crystallize the issues that we're here to discuss. I'll mention that my remarks are based in large part on a report that I co-authored last November called Democracy in the Digital Age, Freedom of Expression in the Americas and Europe's Right to be Forgotten, co-authored with Catalina Botero, Edison's predecessor as rapporteur, and Carlos Cortés, two Colombian lawyers. I have a few copies. If folks are interested, they can be acquired for the cost of a glass of Belgian beer or a croissant or an espresso. And I'll just mention in the interest of full transparency that the report was partly funded by Google, and they in turn complied with our very strict intellectual independence requirements. Very briefly, we argue in the report that the right to be forgotten is an excessive and disproportionate response to a very legitimate concern about online privacy. We do not believe that the right to privacy can justify allowing a politician to disappear allegations of corruption, a doctor to prevent patients from being aware of allegations of malpractice, or a nanny to prevent parents from learning of a prior detention for child endangerment or abuse. Now, some will probably be quick to dismiss these examples as extreme or unrealistic, but one of the problems with the way the right to be forgotten has been applied is that we simply don't know what information is being affected. The vast majority of delisting requests are adjudicated by anonymous employees of private companies with no public oversight or judicial review. The little we do know, for example, from the Google Transparency Report, suggests that individuals, including public figures, involved in crime and corruption are certainly not shy about trying to invoke the right to be forgotten. How successful they are, how often they're successful, is frankly anybody's guess. In Latin America, and Edison alluded to this, dirty politicians with good lawyers have seized, at least begun to seize on the right to be forgotten and invoke it in domestic courts, in some cases and explicitly as an end around when a traditional defamation claim fails on freedom of expression grounds. In one case in Chile, for example, the right to be forgotten was successfully invoked by a former police officer who sought to delist information about his conviction for sexual abuse of minors. So I don't think it's an exaggeration to say that there is a genuine risk here to the free flow of information essential to a democratic society, and we are disturbingly limited, I think, in our ability to assess the scope of that risk. Now, as we're in Brussels, I suspect there are some in this room who might disagree with that view, maybe some at this table as well. And so I'm happy to engage in that debate, or again, you can read the report, which is available in Spanish and English on our website. But what I'd like to do with the rest of my remarks is focus not on trying to convince my European friends that they're censoring the internet, which might take a little longer than the 12 minutes I've been given, but on exploring the jurisdictional and global governance questions that I think this panel is focused on. So let me start by positing three things that hopefully we can all agree on. My first premise is that the instantaneous, ubiquitous, and permanent availability of vast amounts of information on the internet has had a radical democratizing effect, but that these same characteristics generate serious concerns about individual privacy and data protection. My second premise is that, for the sake of argument, the doctrine of the right to be forgotten, developed by the European Court of Justice, is one way that a democratic society might legitimately balance two competing equities. That is, individual privacy on the one hand, and freedom of expression and access to information on the other hand. And my third premise is that just as the application of a right to be forgotten may be a legitimate policy response to resolving this tension, there could also be other equally legitimate ways in which a democratic society might resolve this same tension. So if we can all agree on those three premises, I think begin to see the outlines of the challenge. As it turns out, while all democratic societies that I know of recognize both a right to privacy and a right to freedom of expression, they assign different values to these rights. And that becomes important when the rights are in tension. In Europe, perhaps for historical reasons, there exists a heightened sensitivity to individual privacy rights. In the Americas, also for reasons of history and legal tradition, the right to freedom of thought and expression has been preeminent. I think Edison summarized very well the particular inter-American human rights system tradition around freedom of expression. Article 13 of the American Convention on Human Rights is, I think without any question, the most protective of any of the regional or universal human rights treaties. And so I won't go into the jurisprudence that he mentioned, but suffice to say, I think it's very clear that the right to be forgotten, at least as articulated and conceived by the European Court of Justice, would be incompatible with inter-American freedom of expression standards as developed by the Inter-American Commission on Human Rights, the Inter-American Court of Human Rights, and the Rapporteurship for freedom of expression. So as long as Europe were happy to sort of live and let live, these two approaches could, I think, exist or coexist side by side, maybe uncomfortably, but coexist nonetheless. However, and this takes us to the crux of the problem, the European Court of Justice is now considering a request to apply the right to be forgotten beyond the confines of the EU. Now, from a technological standpoint, this has a certain logic to it, given the nature of the global internet and the flow of information online across geographical boundaries. But the extraterritorial application of the right to be forgotten would essentially override the decision of the democratic societies of 34 countries in the Americas to balance privacy and free expression in their own way. A citizen in Peru or Guatemala or Jamaica might logically ask why an anonymous Google employee in Poland is deciding what they can read on the internet based on a vague set of criteria from a European court. More concerning still, opening the door to the extraterritorial application of the right to be forgotten could quite easily trigger a slippery slope, a race to the bottom led not by democratic societies, but autocratic countries. What happens when courts in Russia demand that Google delist across the world search results linking Vladimir Putin or his cronies to the Panama Papers or to the doping of Olympic athletes? What happens when a Chinese court does the same with search results linking Communist Party leaders to the Tiananmen Square massacre? Now, these issues of truth, transparency, accountability resonate deeply in the Americas, and especially in countries in Latin America, where there's a still recent history of dictatorship and disappearance and so-called official histories, an ongoing struggle for truth and historical memory, and a more contemporary struggle against systemic corruption. So what can be done? And I'll conclude with this. Let me offer three ideas. First, I think we need to broaden the dialogue. I think it's important for national and regional government and judicial authorities to understand the ways in which their decisions could impact the rights of citizens beyond their jurisdictions. And I would suggest encounters between, for example, the European Court of Justice and representatives of the inter-American human rights system would be a good place to start. And hopefully one that also incorporates other relevant stakeholders. Second, I think we need to hit the pause button on extraterritoriality, at least in this context, perhaps permanently. In the absence of an agreed common standard, extraterritoriality constitutes an illegitimate imposition on the rights of citizens to which they have not consented. It creates a dangerous slippery slope that could be seized upon by authoritarian governments, and it could very easily lead to a chaotic judicial standoff wherein, for example, a European court orders a search engine to delist certain information in all jurisdictions, and a court in the Americas orders the same search engine not to delist information in its jurisdiction, or frankly, more broadly. Finally, if jurisdictions cannot agree to disagree, and the extraterritorial application of the right to be forgotten becomes a reality, I think the only solution is some sort of cross-regional or international agreement regulating the matter. Frankly, I don't see how this could easily be achieved, and even if it could, I fear that the consequences might be negative for the robust protection of freedom of expression that we in the Americas have worked hard to achieve. Thank you.
Michael, thank you so much for that crystal clear contribution, and I particularly appreciate the way you wanted to end, if you like. We're thinking about what concrete steps we might actually take in the next few months and years. I'm hoping that our last contribution will follow in similar stead on the basis that you've written a book down entitled Solving the Internet Jurisdiction Puzzle. So I've got great hopes for your last 12 minutes that it'll help put this to bed. So
right.
Dan, over to you.
I'm fearing the PowerPoints now, but could you plus
We'll
be
try,
that
yeah.
one? So the sort of friendly-looking man in the picture here is the character Floki from the TV series Vikings that some of you might have seen. And it might appear an odd picture to start with dealing with this topic, but I'm later on going to try to argue that in improving our attitude as to internet jurisdiction, we can learn a lot from Viking drinking culture, but I'll get to that later. First, I'm going to talk about two cases that will be heard this year that are very important for this data-driven innovation, privacy, and national sovereignty. The first one, you're right, it really doesn't work, does it? Oh, slowly. The first one is the Microsoft Warrant case that has been now reached the Supreme Court in the US, but it's been discussed in several other panels here, so I'll be very brief, but just so that everyone is on board. The matter it relates to the validity of a warrant served on Microsoft by the US government seeking access to data that Microsoft holds in Ireland. So we're talking about personal data. Can it be exported under this warrant? I think that this case will not have any happy outcome, whoever wins. It's a case about how to apply a broken system, so we're not going to get any good outcome here. If the US government is successful, it will be bad for privacy, it will be bad for international relations, and it will be bad for the US tech industry largely. If Microsoft wins, I think that will be better because I think that will hopefully spark reform, but it would be bad for law enforcement, including where law enforcement are investigating privacy violations. We shouldn't forget that angle. And it's also going to be bad in the sense that it represents a cementation of the very flawed territoriality thinking that we are stuck with. Now, what should we do if we want to move forward? We need international dialogue and collaboration. And as I argued here at Cpdp in 2015, we really do need to move away from territoriality as a core concept on which we base our thinking on jurisdiction. But I won't repeat that discussion now, of course. One other thing we need to do on a more practical level is that we have to have much greater precision in the arguments we present when we talk about these issues. And I'll give you some example. There was a lot of amicus briefs filed in relation to the Microsoft case. And one of these amicus briefs was filed by some members of the European Parliament, and they said that personal data located in EU territory is subject to strict rules designed to, and so forth. That's of course not correct. As I include here from the second quote, as pointed out by the Article 29 Working Party, it is not the location of the data that is the anchoring point for when we apply the European data protection law. So if this amicus was aimed at providing clarity as to the application of EU law in this scenario, it actually more adds confusion. There's also problems, I think, with the next one I've listed here. It's an amicus brief filed by Privacy International and a range of other organizations. And they say, if I can read it, to avoid unnecessary conflict with foreign law, this court, as in the Supreme Court of the US, should not read the relevant act as authorizing warrants for data held outside the United States. Again, some sort of focus on the location of the data. But does that mean that we would be happy for US law enforcement to have access to all EU user data if it was stored in the US? I hope not. And it's certainly not in line with how the directive and the regulation are structured either. So let's stop focusing so much on location. Let's move on to the other decision that has been discussed here already. As you know, in the famous Google Spain right to be forgotten decision, something that the court was not asked to deal with was the scope of jurisdiction, as in how far in a geographical sense do these delisting orders go. Does it apply only at the country where the complaint is made, or globally, as Camilleri is arguing at the moment? So we're getting a case now coming before the Court of Justice in the EU on this matter. Unfortunately, the French court, in referring, and I've summarized them here, in referring the questions to the court, has done a very poor job and put everything in a sort of binary questions. But the right to delisting is really a right full of nuances, isn't it? It's not a right that is aimed at ensuring that the data in question can never be found for any searches. It's much more limited than that, and I think, in fact, it could be said to be the right to be delisting is, in a sense, a right to a fair first impression. Yeah, it doesn't go much further than that, and those nuances must carry through also when we deal with jurisdiction. In some situations, I think global delisting orders could be legitimate. If you think of so-called revenge porn and so on, there it might be legitimate that we have global delisting as a result of that sort of content. But if you think about the accurate financial details about this Spanish man in the Google Spain case, I don't see a reason why users in Fiji or Finland even should not be able to find that result. It doesn't serve the purpose, in my view. Now, as already been pointed out, there could be one argument in favor of a global delisting, because the simple reality is that the most effective way to enforce the EU's delisting rules is to give them a global operation. But that reasoning can, of course, also be applied to all other things. So the most effective way to ensure Pakistan's blasphemy rules is, of course, to give them global application, and when we enter dangerous territory. So I think that's problematic. What interests me the most is if we bring these two cases together, I wonder, those who have now put forward amicus briefs in the Microsoft case, will they argue the same thing when it comes to the Google France case? So the EU Commission has said that in the European Union's view, any domestic law that creates cross-border obligations should be applied and interpreted in a manner that is mindful of the restrictions of international law and comity. I hope they express those same views when it comes time to decide the Google France case. I think that's important. Last there is what we can call maybe the privacy advocate's dilemma. Sometimes we have clashes between certain data privacy interests with other data privacy interests. Think about this again with law enforcement trying to investigate a privacy violation, but then the privacy advocates are saying, no, you should not be able to solve this issue if the data in question is stored on a server outside your territory. So we have privacy against privacy, and I think people have not handled that particularly well, really. So let's link it back to the Vikings now. Then. In Swedish, we have a word called lagom, which is often translated as just enough or just right. And it's, according to legend at least, it comes from the tradition that when the Vikings were sitting drinking, people are leaving. Now this is where it gets exciting, people. Anyway. So when people sitting drinking, the drinking horn was passed around. Everyone was meant to drink lagom, meaning you should drink enough to show that you weren't a wimp, but you needed to not drink too much so it would run out before everyone had had a fair go. That concept, of course, contains quite a sophisticated context-specific proportionality thinking that I think we can bring into the internet jurisdiction arena. Of course, there are situations where there's an obligation for states to claim jurisdiction, but there is also a constant requirement that we make sure that we don't overstep boundaries in a sense. And maybe we can see this sort of lagom thinking or lagom mindset as to jurisdiction in the way the Swedish Data Protection Authority has commented on the scenario of the Google France case. Now, I'm not going to read that or anything, but trying to summarize an issue like this in 10 minutes or 12 minutes is, of course, similar to when the chefs on TV try to teach you to cook an 8-hour slow cooking dish and try to go through that in 5 minutes. It just doesn't work. But like the chefs on TV, here's something that I prepared earlier. There's 3 books that you should get if you want to get the full story. They contain everything that I had hoped to say here today, but obviously ran out of time to say. So get the books. I have one copy of that one, the one that Vicky kindly mentioned. And whoever asks me a nice and easy question in the question session will get this book. Thank you very much.
Thank you. Can we have a round of applause for all of our speakers, please? Thank you. I love the fact that in a panel where at least several of our speakers have mentioned the importance of ensuring that anti-corruption measures are enforced at all times. 2 of them have mentioned different forms of bribery as to how to obtain free produce. Wonderful.
Barter, not bribery.
Subtle difference, you're quite right. Thank you. So, I mean, I'm going to open up to some questions, so get your questions ready. Maybe come up to the mic and say who you are. Whilst you're coming out of your seats, I mean, certainly for me, one of the key points I think that I've picked up from this panel is I really like the separation that we've had made, if you like, of sort of the normative implications and perhaps problems associated with 2 particular laws that are going through courts at the moment, but also this much broader discussion of the implications of laws that we're making about citizens' rights online and what the possible boundaries those should be in those cases when it comes to extraterritoriality. I had one quick question, actually, that I just wanted to ask Michael, I suppose, and in a way this gets to the crux of those last two points. You mentioned that, you said, well, maybe we need a pause on extraterritoriality in the absence of agreed standards. And I just wondered whether any of you could think of what might count as agreed standards where actually extraterritoriality might be justified.
So I'd have to think through that a little bit. I mean, at first blush, if you have common standards, you wouldn't need extraterritoriality, right? So I mean, the easiest analogy that comes to my mind is international human rights law. So if you have common standards and you're applying those, even when national courts are applying in cases of universal jurisdiction, for example. So even when national courts are invoking international standards and applying those in ways that arguably are extraterritorial, they're doing it based on the consent that's been provided by citizens through their governments in those other countries. And so you would either have national courts applying the same standards and obviating the need for extraterritoriality, or if extraterritoriality were taking place, it would be based on a much more legitimate basis.
Okay, that clarifies it. That's much more helpful, thank you. And I suppose an example then might be something like the sort of removal of, say, child abuse images, where again, different countries obviously seek agreement to have those removed quickly, but presumably they're taken down from servers within countries based on national laws rather than... Yeah, absolutely. Thank you, that clarifies that. So, I'm going to throw open to the floor. Yes, if you'd like to come up to the microphone and say who you are and ask a concise question. Remember, it can be a nice question. You might get a book. So.
Hi, I'm Lynette Taylor from Tilt. I've been trying to think of a nice question, but I can't, but I would really like the book, so I'm going to have a go. I like the comment that we're not living in a world where the rules we have work very well. That's useful. Are we going to need, thinking further into the future, are we going to need new institutions to deal with the issues of extraterritoriality that we see coming? And if so, what might be a model for the kind of institutions you would like to see emerging?
Thank you, Lynette. Who'd like to take that?
Well, I don't see necessarily need for new institutions, but we need to rethink, in my view, and this goes back a little bit what's in the book, when we need to rethink the attitude towards these sort of issues. Because first of all, there's no, we talk about extraterritoriality as if we knew what it means, but there is no agreement on what it is. That's why we have a Microsoft Warrant case. That's partly about when is something extraterritorial. So there's a huge disagreement about what it even means. What we need to do, in my view, is reconsider the focus on territoriality. So instead of focusing on territoriality as the core of jurisdiction, we would start looking at 3 factors, I suggest. Does the state claimed jurisdiction have a substantial connection to the matter they claim jurisdiction over? Do they have a legitimate interest in it? And there's a difference, because there might be a connection through content sitting on servers in your country, but you might not have an legitimate interest in that information. And the third principle would be a focus on a sort of balancing exercise between your interest behind your jurisdictional claim and any other interests that are relevant. So not a new institution, but a new thinking of jurisdiction. And I think this will unite both public and private international law, in my opinion.
Anybody else want to add to that?
And you can get the book for that. But it wasn't an easy question. So
Thank you, Dan. Anybody else got a question for the panel? Yep, please come up to the microphone.
Yes, hello, Maya Burken from Maastricht University. I have a question for Dan and for Michael, but unfortunately the book is taken. I'll still ask the question. So I'm wondering, I am one of those privacy scholars who did sign the amicus curiae brief in the Microsoft case on behalf of privacy scholars. So I wonder whether there are also some contradictions in there. Maybe you should also read that one. But my question relates more to the Google France case. And that is the part, the third question that the French court asked on geo-blocking. I would like you to elaborate a little bit on that, in particular because in the framework of the digital single market, right now the Commission is discussing the rules on getting away with geo-blocking, and as far as I could hear through the grapevine, this is very much contested within the Commission, and that's why the proposal is not going forward, but the idea behind is to really do away with it. And if the court decides in favor of geo-blocking, wouldn't that go against that idea that the Commission is pursuing? And for Michael, I'm wondering whether you are not actually reading a little bit too much into the judgment of Google Spain, in the sense that it seems to me that you understand it in a way that the court decided how the balance should be struck. That's not what the court decided, even though there is a very unfortunate formulation in the actually operative part of the judgment, but in the end, the balancing between two rights is the balancing that should be done, and I argue that in the end by the public authorities. So if Google does the balancing, there should be a possibility to challenge that balancing in front of a public authority, a court or a TPA. And in the end, I believe that in many of those cases that you mentioned, the balance was struck wrongly. Maybe wrongly is not the right term, but the balance should have been struck differently. So I wonder how you see that point. Thank you.
Thank you very much. Actually, should we go first with Michael? Is that okay?
Sure. Am I reading too much? Maybe. You know, here's the way I would answer that. Yes, I mean, certainly there's dicta in the judgment about protecting information in the public interest, and you know, there's this very vague standard that's set out, which a private party is supposed to sort of interpret in individual cases, millions now of those cases, and there's some resort to eventually an administrative and judicial review of those decisions in some cases. But I would argue that, I mean, first of all, the standard is extremely vague, especially when we think about a standard like that being applied not by judges but by employees of a private corporation. But also that, you know, all of the incentives are aligned in favor of delisting information. That is, the process is such where there's only one party, first of all. You're only hearing this isn't a, there's no equality of arms. There's nothing like what we think of as due process in a judicial proceeding. The party that either generates the content or hosts the content is not notified. It's not able to present its side of the argument and argue in favor of the relevance of the information. And so, from the company's standpoint, there is zero cost to delisting. Nobody ever finds out. So literally, there's no risk involved in delisting, and there's an enormous risk, or a significant risk at least, in terms of resources and financial risk in continuing to in refusing the delisting request, and that then the case gets adjudicated potentially, and if they lose, then they're financially responsible. And so again, the numbers we have suggest that in slightly more than half the cases, the delisting requests are turned down. I think that's positive, but we have no way of really knowing where companies are kind of striking this balance. So I don't think I'm overreading it because of the way the structure has been set up, and I think looking to the future, the manpower involved in adjudicating that sort of system for a private corporation is not insignificant. So we think about artificial intelligence, and some of the tools that may be used in the future to do this in a more cost-effective way are necessarily going to be set up in ways that I think favor excluding rather than maintaining information online.
Thank you. Dan.
Yeah, so the question for me was related to geo-blocking, geolocation. Yes, first of all, first thing we should take a note of, I think, is that France was actually the country leading the way of accepting geolocation in this Yahoo France case in 2000, where they accepted geolocation as a legitimate way to avoid being on the French market, even though the experts said that it was only accurate at 70%. Today it's much, much higher, and now they seem to be viewing it very differently. The EU approach now through the is it a directive or regulation, the one that they're proposing? I can't recall. But the attitude there is, I can see where they're coming from, because geolocation can be used to price differentiate in an unfair way and so on. Deal with that, that's fine. Don't attack the use of the technology as such, because it is going to be turning out to be useful in many settings. In the end, I think it seems like the choice now is either global removal of certain content or removal geographically limited by geolocation. And I've long been sitting on the fence, but I think now geolocation might be, in a sense, the savior for keeping a diverse internet, I think.
Thank you. We have time for one more question, if anybody has a burning question to ask. Everybody's thinking of lunch. I can almost hear your tummies rumbling. I think in that case, I'm going to allow the chair's prerogative, the last question. José Luis.
No, just one question. To Michael and Edison. I can understand perfectly your concerns about the extraterritorial application of the Google doctrine to Latin America, but I think it's another perspective, not a question of extraterritorial application of Google case to Latin America, but the local application of local laws in Latin America. I mean, do you think that, for instance, the Mexican legislation, the Argentinian legislation, the legislation from Uruguay don't recognize the right to be forgotten? So not a question of extraterritorial application, but local application of the local laws in Latin America.
Okay. Yeah, good question. My concern is in the both sides. Really, the decision of Costeja now in Latin America don't have or don't recognize a right to be forgotten under the Article 13 of the convention, and the countries now, I don't know, is some countries discussing in the Congress a definition of right to be forgotten, but I don't care that, I don't have in mind. But really, there is a confusion about the concept and what is the scope of the concept. And this is not a problem of the right to be forgotten in Europe. It's a problem with our acknowledge of the concept. In many cases, to protect the owner, for example, somebody called to the court or going to the court to ask for remove. And this is not the remedy for this case. The case is ulterior responsibility, civils or penalty responsible. But in a case against the newspaper El Mercurio in Chile, in this case, the order is not for the platform or the intermediary, in this case Google. The order is against the newspaper to remove of their web page this content. That it's like a mix between right to be forgotten and honor protection. No, I think I try in a recently publication of our office, Internet Open, Free and Inclusive, to explain this situation and say, well, we need to distinguish what is the right to be forgotten in Europe, what is the way or the form to protect the honor in Latin America, and different kind of censorship that is prohibited by under the convention. No. And then, well, also we are expecting of the result of this case, French versus Google, but because the other concern is the effect that this have in the region. We have another case in Mexico that a businessman called for the Data Protection Authority to remove some content, and the data protection go in the same way that the Costeja case, but the Constitutional Court, annuló the case because the third part is in this case a newspaper never take part of the process to maintain, because this is other concerns, the impact that this type of measure have in the media to access all of us access to the media through the certain engines, and it's not there is not a process to prevent the participation of the third parts in this case. But
I think we need to bring this panel to an end, and as we do, I'm going to ask José Luis if you have any last words before we go.
Okay, well, thank you very much for everybody. Thank you very much to Victoria, Michael, Dan, Edison, Ariane, for this amazing roundtable, from this amazing panel for all the questions. And let me thanks also to Rosario Duaso, the academic coordinator of the Google Chair, for her job. Without her job, it was impossible to organize this panel. And thanks to organizers, and in particular to Professor Paul de Heert for the invitation to participate in this seminar. I hope we can see next year in this event. Thank you very much to everybody, and see you next year. Thank you very much.